Hello and welcome everyone to the CDS Global Cloud webinar, From Policy to Practice, Implementing China's New Cross-Border Data Regulations. I'm Mark McNeil, Director of Global Sales here at CDS. We're a public company licensed to operate in China with a 20-year history as a data center and layer 2 network supplier. We provide services such as bare metal, co-location, managed cloud services in over 90 data center locations around the world. We also offer a fully meshed global private network that enables our customers to build WAN backbones, point-to-point Ethernet connections, international Ethernet private lines, SD-WAN services, and virtual private networks. In addition, global enterprises who have locations, customers, or employees residing in China rely on our signature global DIA service to provide high-quality cross-border data transmission solutions. As a member of the China Cross-Border Data Telecommunications Industry Alliance, the recent release of the new regulations by the Ministry of Industry and Information Technology is of key importance to CDS, as it is to all of you joining us today. Many have very different interpretations of cybersecurity regulations in China and often question how to best connect their locations in China to the rest of their global networks. We at CDS help customers like this navigate those regulations and requirements every day, while enabling them to achieve seamless, dependable integration with the rest of the world. Today, we have a very special agenda planned for you. Our guest speaker is Mr. Han Wu, a partner at King & Wood Mallesons, a top international law firm. He will be covering the following topics for us: an overview of these new regulations, what is the impact of these new regulations on international businesses, compliance strategies that you can follow to align with the new regulatory requirements, and what's going to happen in the future with data regulation. Mr. Wu has a long history of achievements in regulatory and compliance law. He has been named one of the 40 under 40 lawyers by Global Data Review, a next generation partner for 4 years running by the Legal 500, and a leading lawyer for the past 3 years by the Chamber's Greater China Region Guide. Please note, we will be taking questions after this presentation. You may enter your questions into the chat. This webinar is being recorded, and you will be provided with a link to that recording. So without further ado, it is my pleasure to introduce Mr. Han Wu.
Hi, guys. Thank you, Mark. Thank you for giving this nice introduction and the opportunity to present China's new CBDT regulation. On March 2024, the Cyberspace Administration of China officially released this new regulation, basically overhauling the existing regulatory process governing the cross-border data transfer. And on the same day, the CEC also issued 2 guidelines specifically for the CBDT security assessment, as well as the standard contract. Together with all those guidelines and regulations, the CBDT regulatory roadmap or the pathway has now looked different. And this is because, like, since the implementation of the back then existing regulatory mechanism in the late 2020, the process had its course, but there are lots of practical problems. And our team has also engaged in the legislative process by summarizing all of those issues raised by the companies, and also help the regulators to identify the areas that can be improved. So against this drop, this new regulation is issued. So this is basically the overall roadmap of this new regulation. And what has not changed is that under the new regulation, it is, as always, only the important data and the personal information is regulated. For any other types of data that is not important data or not personal information, it can transfer from China, right, freely. And for the important data, it still must go through this security assessment process, which is a two-tiered ex-ante approval regulated by the CAC. And the important data is, well, it's still a kind of ambiguous concept right now, but generally it refers to the types of data that can impact the national security and the public interest, right? And for the personal information, there's lots of change. So for example, under this new regulation, there are now lots of exemptions. So, and under those exempted scenarios, while those related data transfers can transfer from China without the need to go through those lengthy regulatory process. And also, there's this new invention called the negative list, which will be, well, which is generally issued by the free trade zones across the country. So any data that is, well, being like listed on those list, right? Those data can be transferred from China without the need to go through regulatory process. On top of those, the new regulation also changes the threshold triggering the regulatory process. So before this whole new regulation, every data transfer from China must either go through the security assessment or it must go through the SEC filing. But now, with the exemptions, there are the certain types of data transfer activities do not need to go through the process, and also the number of companies that will be triggering the security assessment process will be significantly reduced. As shown here, right? So if, for example, if we don't have any exemptions, we don't have those negative lists, and then the company just need to determine whether we have any sensitive personal information. And if we do, then the company at least need to go through the standard contract filing process. But if the company does not have the sensitive personal information, the next step is to determine whether the company has, well, over 100K personal information. And based on those two standards, we can determine whether a company need to go through a security assessment or need to go through the standard contract filing. One thing to note here is that if you look closely on the SEC filing, we also have this certification, right? So legally speaking, under China's CBDT regulatory process, a company can also like choose between the SEC filing and the certification. But so far, most companies, especially the multinationals, they prefer the SEC filing path because it is it provides a lot of flexibilities and it does not involve a third-party agency to do some on-site inspections, which are required during the certification process. Okay, so what is a CBDT under the China law, right? Generally speaking, there are three circumstances. First is that when a company collects and stores the data in China and then transfers the data outside of China, right? That's the most straightforward way. The second thing is that if a company collects the data and stores the data in China, but allows someone located outside of China to access or to download the data, then that is also a cross-border data transfer. And lastly is that a company, for example, the company is itself not located in China, but it has like a set of applications or websites that can collect data from China. For example, someone in China, a customer, a user can just key in the data into the website or the application. Then in those circumstances, that will also be considered as a cross-border data transfer. This is the last scenario that we call it direct collection. is something that is newly added in the second edition of the guidelines, right? But it is not a new concept, or let's say like the scope of the CBDT is actually not changed. The reason is that before, like in the first edition of the guideline, the direct collection is still a cross-border data transfer because it's something that can be read between the lines. But in practice, we do note that a lot of companies, they will have some concerns about this, and that's why in this second edition, the regulator has made clear that those direct collection is in fact a cross-border data transfer. But we also want to note that it's not like every direct collection cases should be subject to the like China's CBDT regulatory process, because for a direct collection to be subject to the regulatory process, the collection itself must be subject to the personal information protection law of China, right? Because the law must have the jurisdiction first. And under the personal information protection law, it is only when the collection is intended to provide products or services to people located within China, or for the purpose of analyzing or assessing the behaviors of such persons within the China. So only when the collection is for those purposes, then the personal information protection law applies, and here goes the CBDT regulatory process applies. Okay, so the next key issue is like who should bear the obligation to conduct the cross-border data transfer related obligations, right? In short, it's the data handlers. Data handler is somewhat similar to the concept of data controller under the European's General Data Protection Law. It basically means an individual or an organization that can independently decide the processing purposes and the processing means in given data processing activities. So in terms of CBDT, it means that it is a company that can decide or the companies that demands the CBDT. This is important because in certain cases, the transfer itself is initiated by we call it entrusted possessor, or basically it's the agent, right? The agent may be the party that is actually doing the transfer, but because the agent is doing the transfer in the name of the data handler or in the name of the principal, so in those cases, it is still the principal or the data handler bears the obligation to ensure the CBDT is compliant to go through the CBDT regulatory process. Another key issue is the scope of sensitive personal information. So as we previously mentioned, under this overhauled CBDT regulatory process, as long as the company transfers a single individual's sensitive personal information, that company must go through the standard contract filing process, right? But if the company transfers like zero sensitive personal information and less than 100K individuals like non-sensitive persons, that company can be exempted. So it brings like the scope of sensitive personal information to be a very critical issue. Under the personal information protection law, the sensitive personal information is defined as those type of data of which like the leakage or illegal use could easily lead to the violation of personal dignity or like harms the person's like property safety. common examples are biometric identifiers, religious beliefs, specific identities. For example, a person's national ID card, a person's social security numbers, things like that. Types of data that are related to healthcare, financial accounts, etc., and like also person's location and tracking related information. And notably, all of the like personal information related to a minor under the age of 14 are considered sensitive. So this brings like a very interesting topic actually. So for example, in China we have this national ID card, right? It's much like the social security number in the US. We need to fill in our national ID card in various government process, and the government use that number to identify us. So obviously this national ID card number, right, may be considered as sensitive personal information. But how about other information on the same card, such as like my ID card's expiration date, the issuing agent, my ethnicity, right? All of those information may or may not be considered as sensitive personal information. And another interesting issue is about the identification. So under the like the China data protection laws, de-identification it can only like change the sensitivity of data, but not to achieve the anonymization effect, right? And if we, for example, we mask like several numbers of ID card number, right? And does in those cases does like the de-identified national ID card number still be considered sensitive? Our position is that it's likely, right? But somehow this answer and the specific answer to this question may need to be subject to the opinion of the local CAC staff, because they may have some discretion in like giving some guidance. But in our experience, there are some wiggle rooms. If you do have a good argument, you can argue with those staff and convince them that, okay, after the de-identification, the data no longer have the effect to lead to the violation of personal dignity and property safety. Okay. Another like critical issue about like data volume, because data volume is something that if a company is not completely exempted, then data volume is very important for a company to determine which compliance path to choose, right? Under the CBDT new regulations, data volume should be calculated from the January 1st of the current year. But there are several caveats. So first is that the total number should not only include the newly transferred individual, right? So for example, if I have like 10 accounts opened up within 2024, and I need to transfer those like new accounts information outside China. But also, if I already have, say, 50 accounts opened up in 2023, but in 2024, I still need to continuously transfer those 50 accounts data from China, then in those cases, in 2024, the total like count should be 10 plus 50, 60. Because from the CAC's perspective, they still consider the continuous transfer as a new CBDT, and hence should be counted with by this data volume. And another caveat is that those individuals involved in the exempted scenarios should be excluded from the the threshold calculation, as well as those excluded by the means of negative list, right? And another important point is that for CSA, the numbers need to be deduplicated, which means that, for example, if a company transfers my personal information in 2023 and also in 2024, then that should be only counted as one rather than two, right? Okay. So that's the method of calculating the number itself. But what should be the basis of the number, right? In China, some large, especially some large multinationals, they do have lots of legal entities. Should they count that number per legal entity, or should they count that by scenario? So generally speaking, it should be counted by this concept of data handler, because it is the data handler that bears obligation, which means that it could be like a single legal entity, but it could be a group-wise calculation. So for example, a group company in China has say 10 subsidiaries in China. But just to improve the efficiency of human resource management, the group only asks the one legal entity to handle all of their the subsidiaries HR related issues, right? In those cases, it could be like that all of the employees of those 10 subsidiaries are managed by a single legal entity. In those cases, though that legal entity is the data handler, but the number of individuals should be counted based on the total of 10 legal entities. And if like a data handler meets the threshold, then all of the related entities, or say the legal entities covered by that data handler, should go through the same process. So let's just say that HR managing entity had hit the threshold of 10K sensitive personal information. Then that's a company, that legal entity, along with 10 subsidiaries, should all go through the security assessment, right? Including the scenarios where the company only transfers non-sensitive information. For example, the company only transfers contact person's details of one of its vendors. Then those transfer of the vendor's information still needs to go through the security assessment. But it is only that the entity, like the legal entity being the data handler, need to submit the actual documents and to go through the process. The other 9 subsidiaries only need to provide facts and may need to provide POAs for the data handler to complete the process. And here we also want to make a point is that the distinction between the sensitive and non-sensitive information is only used as a basis for choosing the compliance pathways, right? So it's either security assessment or standard contract filings. Once the pathway itself is determined, in theory, the both sensitive personal information and the non-sensitive personal information must be submitted for CSA approval. Just to as a follow-up, like to the points we just discussed. So there are kind of several examples we can see. So for example, a company that transfers 30,000 like non-sensitive information in scenario A, and 12,000 sensitive personal information in scenario B. Because here the company has like meet the 10,000 threshold, so the company need to go through the security assessment process for both scenario A and scenario B. And in the next example, if there's only say 8,000 sensitive person information and in scenario A, and also like 4,000 sensitive person information in scenario B, then because the data handler has combined together, like has more than 10K sensitive information, then this company must also go through the security assessment. In the last example, right, the company only has like 8,000 sensitive person information in scenario A, and also 4,000 sensitive like person information of its employees, which are eligible for one of the like the human resources management exemption. Then because the number of individuals in the exemptions can be exempted, then the company is actually like well transferring 8,000 sensitive information. So which means the company has not reached the 10K threshold, and therefore the company can just go through standard contract filing process. So as mentioned before, under this new CBDC regulation, there are like 4 exemptions. The first exemption, we call it the data in transit. It basically means that if the data itself is generated and collected outside of China, and then it's transferred to China for processing, and then it's transferred outside China. So in those cases, the transferring data outside of China does not need to go through like any of those CBDT regulatory process. And what is not explicit in the regulation is that the processing activity in China cannot introduce any new like information or important data generated within China, right, during the processing. This is to prevent that this exemption in fact creates a loophole in the regulation, right? The second exemption, we call it like a contractual necessity exemption. It basically says that if the cross-border data transfer is necessary for the conclusion or performance of contract to which the data subject or the individual that the information is concerned is a contract party, then those CBDT can be exempted. The new regulation also gave some examples of these contracts. For example, the cross-border shopping, the visa applications, and cross-border payment, things like that. And interestingly, based on our communication with the CC, the CC is currently treating this list as an exhausted list, meaning that they only recognize what has been stated here. So for example, if I have an insurance policy with a Hong Kong insurer, then and I definitely need to provide my information to the insurer in Hong Kong for claim processing, right? But in those cases, the cross-border data transfer is not exempted, even though I am like I basically can satisfy all of the elements under this contractual necessity. But because the like insurance contract is not the type listed under the new regulation, the CAC currently does not recognize the insurance policy related contracts. In our view, this may be CAC's attempt to minimize the abuse of this clause, because after the new regulation is issued, we do get lots of questions and inquiries asking whether they can use this exemption for lots of internal arrangements. So, for example, a company they use SAP for their financial payments, right? Even though they are just paying some local vendors in China, but because their financial system is SAP, they still need to output. They still need to transfer the vendors' like bank accounts and other detailed information to SAP, which is typically hosted outside China. In those cases, the CSA's view is that while the CBDT is not necessitated by the contract itself, it is necessitated by the company's IT infrastructure, right? So CSA does not view like those those payments or those contractual arrangements can satisfy the requirements of this exception. Another interesting exception is the human resource management. This is a overdue exception actually, because in practice, lots of multinationals they definitely have the need to transfer their workforce's information of China, right, for for overall management and also for collaborations. But there are some caveats here. The first is that the human resource management need to be cross-border in nature and also need to be in compliance with the company's internal rules and policies, which also must be developed in accordance with the China's labor contract law, or based on a collective bargained contract, right? So there's lots of procedural preconditions the company need to satisfy to rely on this exception. Another caveat is that this exemption, based on CSA's current position, only applies to formal employees, which means candidates, expatriate workers, interns may not be able to enjoy this exemption. Especially here, the candidates data in lots of like pre-new regulatory new rule era. In lots of our projects, we do see CSA rejected some companies' application to transfer candidates data outside China because, in their view, many of the the higher decisions can be conducted locally, so the company does not need to transfer every candidate's data outside of China. That's one of the reasons from my personal view that's why CSA does not want to include the candidate within this exception. But that is not to say that all of the candidate data cannot be transferred outside China, right? In lots of cases, a candidate's direct line manager is located outside China, right? In those cases, the resume of the candidates must be transferred outside China for the line manager's review, to conduct the interview, and also make the hiring decision, right? And lastly is the emergency circumstance exemption. This is rarely used. Except for certain hospitals and insurance policies. It basically says, for example, if I traveled to the US and I happen to be involved in, say, accident, and I was hospitalized, right? Then the doctor may want to get my medical records in China to see if I have any, say, allergies or I have any preconditions, the doctor in the US may want to take those information into consideration. And in those cases, in those cases, the doctor may ask me or ask the hospital in China to provide my medical records, right? And if if those kind of cross-border data transfer still needs to comply with the the CBDT regular process, it's gonna take months. And by that time, I may already be released from the hospital. So this exemption is designed for those limited circumstances. Okay, another example question here. So for companies that due to the payment system setting, need to provide bank account information of 20,000 individuals, suppliers information abroad, then the company, right, still need to go through the CBDT regular process because this data transfer cannot rely on the cross-border payment exemption or the contractual necessity exemption, because here the cross-border data transfer is not necessitated by the contract itself, but rather necessitated by the payment system. And because because the bank account is sensitive personal information and the number is 20,000, exceeding the 10K threshold, so the company need to go through the security assessment process. Okay, so this is what we actually have discussed. The necessity here is the need or the necessity for the cross-border data transfer. It's different from collection when we collect the data, right? Here it must be judged by each case whether it is truly necessary for providing such data outside China. And overall, the CAC is currently adopting this case-by-case review process. So basically, it says that, okay, there are some precedents which are, of course, of value for reference, but each company's situation is different. The CAC will take the totality of circumstances to determine whether they believe there are necessity. So for example, like the candidates we just discussed, some companies, they aside from actually conducting interviews, right? Some companies, they do have this global resource pools. They ask candidates to join those pools, and if the candidate says yes, right, then the data is shared globally for talent identification and recruitment. And that may be one of the valid justifications for transferring such candidate data outside China. Okay. Oh, important data. Important data is kind of headache. So basically, under the data security law of China, important data need to be identified by the relevant regulatory agencies, and they need to provide this so-called important data catalog so that companies can know which types of data important data. But the important data identification is, I would say, kind of difficult because it actually involves lots of considerations, especially determine the determination of like national security concerns, and also the regulatory agencies also want to avoid over expanding the catalog so that it may hinder the economic development. So far, only a limited industries have published this important data catalog. And what the CSA's view is that if a company does not know, right, either publicly or privately, that certain types of data is important data, then that company does not need to file that data as important data during the cross-border data transfer security assessment, right? So basically, if you are not sure about whether a type of data important data, the first thing a company can do is to refer to the relevant like existing national standards and guidance for guidance to see whether there may be some risks. And if there is no such risks, then such data is not important data, right? The company can then transfer the data outside China without the need to go through the CBDT regulatory process. Okay, the negative list. It's basically is like each free trade zone now is empowered to create this negative list, and error data in the in the negative list must go through the CBDT regulatory process, right? So it's not like a white list; it's a negative list. But in practice, each free trade zones are treating this somewhat differently. So so far, China has issued two negative lists, one by Shanghai and one by Tianjin. Tianjin is the first negative list issued about 2 weeks ago. Yeah. And Tianjin's approach is that they basically does not change any like personal information related matter. For personal information, Tianjin agrees with the new regulation. Everything remains the same. But what Tianjin does is that it aims to provide more clarification on the important data identification. Tianjin provides a very long list of types of data that in Tianjin Free Trade's view may be considered as important data. And if a company is based in Tianjin's free trade zone, that company need to like apply for the security assessment for those like the important data identified by Tianjin's free trade zone, right? So that's the Tianjin's approach. But in Shanghai, negative list is issued last Friday. It's somehow different. It's only concerns about the personal information. And it provides 3 lists for the automakers, for like the pharmaceutical companies, as well as for the funds. So for the 3 lists, the Shanghai Free Trade Zone provides some examples of some data types that can be transferred freely from China. So although it's called negative list, it is actually a white list, right? And if a company wants to apply for Shanghai's negative list, the company need to first consult with the Free Trade Zone's agency, and then need to go through a similar filing process with the Free Trade Zone. But after the filing process, the data listed in the list and as filed can transfer freely from Shanghai's Free Trade Zone. And Beijing also has a free trade zone. Hainan also has a free trade zone. Each free zone may tackle this issue differently, and we do believe eventually their approach may merge, right? Because they also want to attract new opportunities in their respective zones. So they wanted to provide more, the lenient, well, and also the more compliant ways for companies to transfer data. Okay, that's basically like my introduction of the new regulation.
Thank you, Mr. Wu. That was excellent. Great insights, and I love your explanations. In fact, that pathway slide is awesome. Just a visual guide of looking at your specific scenario and tracking it through to see, am I exempt? Do I have to, go through some kind of an examination? And if so, which kind? I really appreciate that. I think that was very helpful. We do have a couple of questions if you're ready to take some.
Yeah, sure.
Okay, great. So we have one attendee here. Let me give you some background here. They were looking at the key issue slide, point number 2, where it refers to the 10,000 record threshold. And the
Yeah.
question is, am I right in understanding that very small companies with less or even much less than 10,000 sensitive PII instances don't need to file anything? Is that correct?
Thank you, Mark. I would say it's depends. So, for example, if this very small company, right, still have a single sensitive personal information, then it still need to go through the standard contract process. Let me change to the pathway slide here. So basically, if you have a sensitive personal information, then you must go through the standard contract process, regardless of like the non-sensitive information. But if the sensitive information exceeds 10K, right, then it's just need to go through security system. So in a way that this new regulation provides some exemptions, it's also tightens the controls over sensitive personal information. But there's a but. But if the data transfer of the sensitive personal information falls within one of those exemptions, for example, the the human resource management exemption, right? Then those numbers can be excluded from the calculation of the threshold. So, for example, a small company likely transfers its employees, say, bank accounts, right? Then those bank accounts should be excluded when we calculate the sensitive personal information. Yeah.
Right. Great. Okay, thank you. We have another question. So basically, and I'm paraphrasing from the question here, basically, some people have said that this does seem to provide a lot more flexibility for businesses involved in cross-border data transmission and even what some would call self-regulation. Do you feel that that is true and that's what the ministry was intending? And if so, is there still going to be some observance over what companies are doing to make sure that they are in accordance with the regulations?
Yes, thank you, Mark. Generally, I would say I agree. This pathway does provide lots of flexibilities to companies, especially compared to the previous, like the overall regulatory regime. And significant change under this new regulation is that the regulator, they are shifting from the ex ante approval to the concurrent oversight and the ex post regulation. So, which means that the regulator is actually relying on companies to do your work, to make sure you have good internal process to do the filing. But the regulator gonna pay less attention to the documents you submitted. But I'm seeing that just as a comparison to the previous state, but not saying that they do not pay any attention. They still pay attention, but it's less attention compared to the previous state. And they will monitor the cross-border data activities. And if they see there's an issue, they will knock your door and ask lots of questions. And if the company already have sufficient internal controls, have sufficient internal process to prove that, okay, we are compliant, then that's gonna be a quick discussion, right? But if you don't, then there's gonna be some kind of troubles. Yeah.
Understood. Thank you. Well, I don't see any more questions in our chat. So, Mr. Wu, I want to stop there and thank you so much for your time and as I said earlier, for your explanations of these new requirements. Very informative. I want to also thank our audience for attending. If you have further questions, we here at CDS are happy to assist you with solutions and even connecting you with Mr. Wu and the law firm. I want to thank all of you for attending the webinar. You will be receiving a link to the recording, so look for that in your email. And one final thank you, Mr. Wu. Thank you so much for your time, and everyone have a great day.
Thank you, Mark. Thank you for having me. Thank you.
Mhm.
Thank you.
Bye, Mark.
Thanks, Vivian.
Thank you.
Bye-bye.
Bye.